Today on Categorical Imperatives, we are going to be talking about Donald Trump's re-election strategies after November 3rd. We are going to be looking at what he did wrong and what he didn't do right. Hey, greetings and welcome back once again to Categorical Imperatives. As always, I am your host, Lockie Liberal, and I do want to thank you all so much for being here with me today. If you are new to the program, I want to welcome you. This is a podcast where we're going to be applying legal theory and moral philosophy to current events related to law, politics, and culture. Now, uh, this episode today, I think maybe might need a quick disclaimer. I realize following everything that happened on January 6th at the Capitol, that the tone and the dynamic of this episode may have necessarily changed from what I intended it to be. I researched this and wrote this well before the 6th, so I just kind of want to put this out there that uh, consider this show nothing more than a legal thought experiment. This is not an endorsement of, nor is it a condemnation of Trump's claims of fraud or a stolen election. This is me using current events to do what I do best and what I love to do with you guys, and that is teach you about constitutional law. And all I want to do here is take an objective look at the situation and say, after November 3rd, uh, basically a hypothetical question that if Trump's claims of fraud had been true, what could have been done to effectively challenge the election that may have had a chance of success? Something I have heard not only from Trump's rhetoric, but from every Donald Trump supporter that I have talked to about this is they all say the same thing, that he has exhausted every legal means available to him. That is simply not true, not even close to true. In fact, he's exhausted almost none of the resources that were legal resources that were available to him. And so that's what I want to talk about this today. So again, this is neither an endorsement or a condemnation of any person, party, or group of people. So this is really just a chance for me to talk about an area of constitutional law that I think is really largely unknown. And by that, I mean, in fact, that this is an area of constitutional law that many lawyers are probably unfamiliar with. And even probably many constitutional lawyers do not really understand very well. For those who don't know, in law school, uh, really most law schools never get around to this because they never get around to the vast majority of constitutional law. When you take your 1Ls there, I mean, everything pretty much starts with the Marshall Court in 1803, and then it jumps straight to the Reconstruction era around the 14th Amendment of 1865, and then it just suddenly jumps again to the New Deal era, and that's it. That's pretty much everything. So, um, anyways, I hope you guys find this episode interesting, and I want you to feel free to go ahead and subscribe to the channel if you haven't already done that, and share this video if you like what I do enough to have earned your support, and you want to take a moment and share this video. Either just share it out to your favorite social media network or site, or even if you can just think of someone you know personally who you think also might dig what I do, and you just want to take a second and reach out to them specifically with the link to the show and just ask them to check this out. I really genuinely appreciate everything that you guys do to help me grow this channel at all. So thank you. And so with that, let's get on with the show. Now, this started with me doing something that I really should know better to and never do. And that is discuss politics on Twitter. I have spent a good amount of time lately explaining why Trump's election challenges won't work. And they mostly come down to his representation for these cases being really less like lawyers and more like conspiracy theorists with law degrees. Rudy Giuliani, Sidney Powell, I am looking at you here. So rather than the team he really needed, which would have been a lawyer with an experience in constitutional and election law, some kind of information and technology specialist, someone with good PR skills, and most importantly of all, a top tier civil litigator. Unfortunately, the team he had did absolutely nothing you would expect a competent legal team to do, and everything you would expect a raving, half naked schizophrenic standing in the middle of the street yelling at nobody to do. The people I was discussing this with were convinced that Trump had done absolutely everything he could, and they had looked at this problem for every single angle, and everything had been exhausted, and all avenues had been explored, and therefore the Supreme Court failed him, and so they're fucking cowards and traitors, and the vice president failed him, and so he's a coward and a traitor, and uh, basically blaming everybody except the very, very, very small handful of people who are actually responsible for Donald Trump's loss, which is mostly Donald Trump, but then after that, in a very close second, would be Rudy Giuliani and Sidney Powell. So today I want to explain why I was correct in saying that there were avenues that Trump did not explore that he could have. And if you haven't seen my past videos talking about some of the other cases having to do with this, I recommend you check them out. This starts with this one here, which talks about the case of Texas versus Pennsylvania, and moves on to this one where I talk about standing as a legal doctrine. The next, I did one called Pence Shrugged, which was really a bit more of a lighthearted look at the absurd way a contingent of Trump supporters are twisting themselves into knots trying to rationalize how he can win a race that was over and done with weeks ago. And finally, my most recent video was one that I called Pence Problem, and this explains why this insane notion that the vice president can unilaterally overturn an election is an entirely meritless argument, and I go to great lengths to show you why that simply could not and possibly at all be the case. So, two important things to keep in mind here is that the way the states handled their election laws in the days leading up to this election, despite what Trump has claimed, the way they handled their laws was not a violation of their own state laws. And also, the other thing to keep in mind is that the supposed second slate of dueling electors that they said they had sent up was not a slate of electors at all. It was really nothing more than a group of Republicans in certain states who got together and decided that they can be electors just because they feel like it. And so even though they weren't picked by their state to be actual electors in the Electoral College, they all just decided to write down a vote for Donald Trump and send it off anyway and pretend that they were members of the Electoral College, which they were not. But the fact is, no matter who committed what fraud, after November 3rd, Donald Trump's biggest foe in this case was Donald Trump. So let's get into what he did wrong, and more importantly, what he didn't do right. Now, the first thing to recognize is that this election was over on December 14th. Absolutely everything he did after that was a completely wasted effort. December 14th was the day that this entire fight became fruitless. Now, many people have been claiming that that day was just a meaningless date set by statute to decide when the electors vote. And actually, that date is specified by Congress in pursuance to a special invitation in the Constitution in a clause that is known as the Same Day Clause. Now, its purpose is to ensure that the electors all vote on the same day. And that's why it didn't matter that the state legislatures were trying to look into a second slate of electors after to essentially change the way that their state had voted. Their electors had voted on the 14th, and that cannot be undone. A same day vote by the whole of the Electoral College came and went on December 14th, and that was the end of it. So the same goes for the date the election was supposed to take place, which is set by statute by Congress by special invitation of the Constitution, and that is found at Article 2, Section 4, Clause 1. And this means that once that date is established as voting is protected in the Constitution as a fundamental right, that a mail-in ballot voting system, as was specially set up this year, could be argued to be a violation of that right as part of the 14th Amendment's Equal Protection Clause. Now, Trump nor his lawyers ever considered this. He wasted his time by saying that mail-in ballots will make Democratic fraud easier, and essentially saying that if he loses, it'll be because the Democrats used mail-in ballots to change the vote totals, so Biden won, even if Trump, as he claims, had the most lawful votes. Now, that has been his complaint all along. That he would have won if Democrats didn't cheat. So the handful of problems that this assertion was the fact that asserting from the beginning that this is how everything was going to go down, to me, seems to be a very cowardly way of giving himself an excuse for failure if he lost. It's the same thing he did in 2016. The entire campaign, his line over and over again the entire time was, this is a rigged system unless I win. If I win, it's a fair election. If I lose, they cheated. I'm sorry, that is the act of a fucking coward. It has to be said. So, for any Trump supporters who are upset with me for saying that, if he isn't a sore loser, I just have to ask, how is it that despite the fact that he did fairly win the 2016 election, he never accepted the fact that even though he won the Electoral College, which is the vote that matters, and lost the popular vote, which is still a fair win, for 4 years he has never deviated from his entirely baseless assertion that he won the popular vote too. Does that sound like the actions of anything except a sore loser? But anyways, back to my main point. This entire election, his strategy was, if I lose, it's because I actually won, but they cheated. Now, had he had competent lawyers who understood the Constitution and election law, he would have realized that he didn't have to prove that the election was stolen from him. He would have just needed to demonstrate that the same-day clause in Article 2 and the Equal Protection Clause in the 14th Amendment, and to a certain degree even the Privileges and Immunities Clause in Article 4, essentially establish a system where votes trickling in over time creates an electoral disparity and an information disparity. By which I mean, if we have some inclination who has been voting by mail, it's very easy to figure out through analytics who they are and who they likely voted for. Now, this means that if there were more people from one voting bloc who had already largely voted in favor of a certain candidate, he could then change his political messaging and throughout the campaign, essentially, and start sending a different, possibly even a conflicting message to another voter group who may have had goals contrary to the group whose support he already knows that he had won. And by information disparity, I mean, as we got closer to the election time, we started to see it suggested that, and there was actually a decent amount of evidence that, not only is it that Hunter Biden seems to have been engaging in a corrupt business of influence peddling, but it really kind of looks like creepy Uncle Joe may have been directly involved in this as well. Now, you may well remember that there was a point where many people who had already mailed in their ballots and were later finding out that they had voted for Biden before knowing these things about him that other voters knew before they cast their vote, that they were actually very unhappy about this, and that there was a number of people who were trying to see uh, what they could do to essentially try and get their vote back and see if they could uh, uh, call back in the mail-in ballot that they had sent in, so to speak. So essentially, they were happy voting for a creepy hair sniffing pervert, but if he's also a corrupt influence peddler as well, that goes too far. I mean, perverts are one thing, but corrupt perverts are something entirely different. But that is what I mean by information disparity. Trump didn't have to prove Biden cheated. All he had to do was use those kinds of constitutional arguments to claim a violation of the Equal Protection Clause. That is a much lower threshold of evidence to prove and would open him up to do a number of things. So let's take a look at what he could have done after the election if he had had competent lawyers. Now, what is interesting is that technically, if you look to the Constitution, you do not actually find the Electoral College in there. Our ability to hold a popular vote in our states for which electors are sent is really a gift given to the American people by their state legislatures. Now, the court has ruled that once that right is given, that it is indeed a fundamental right and cannot be taken away. But ultimately, that means state legislatures have the ultimate control over which slate of electors that they send. Now, there is a congressional statute that says if an election is held on November 3rd and it does not produce a winner, then the state legislature should go ahead and either set up a mechanism for to produce a winner. Uh, see, by either setting up a snap election or by picking a new slate of electors themselves. So the real issue is, as far as state legislatures were concerned, should not have been did Trump win rather than Biden win, but was there enough of a mess here to have justified either setting up a new election, a snap election, uh, or petitioning the state legislatures to choose the slate of electors themselves? And what was striking about this election is that even though there was a convincing muddle in perhaps as many as 6 different states, not one state legislature and 5 of those states had Republican controlled legislatures. Um, if they would have just manned up and done what they were supposed to do under the Constitution, which is to investigate, hold hearings on the issue of whether or not there was a clear winner, and if there was not a clear winner on November 3rd, to either call a snap election or to choose the electors themselves. Now, what is fascinating to me was as these legislators were looking into how they should handle this issue, they had some really poor excuses that show that they were very poorly advised by their own legal counsel. So you would often hear excuses like, well, our governor won't call us back into session, or, well, our governor would veto legislation we passed to make this happen. Now, this is where a component of constitutional law would have been that a competent constitutional law attorney would have been very, very helpful with. Because in either choosing another day before December 14th to have a snap election or to set up to choose the electors themselves, what happens is those state legislatures uh, essentially perform a duty given to them directly by the U.S. Constitution. The courts call this a federal function. Now, what is a federal function, you might be asking yourself? And that is a good looking question. So, the U.S. Constitution grants enumerated powers to officials and agencies of the federal government, but The Constitution also grants powers to persons and entities outside the federal government. Uh, these persons or entities can include state legislatures as free standing assemblies. The state legislative apparatus as a whole, including the legislature, the governor's signature, and the initiative and referendum process. State conventions, state governors, voters in federal elections, jurors in federal courts, presidential electors, and conventions for proposing amendments, also known as Article 5 conventions. Now, when those persons or entities exercise constitutional powers, the courts say they are carrying out a federal function. And the authority to exercise these federal functions ultimately comes from the Constitution rather than from rather than from federal or state law. And thus, with some exceptions, neither state nor federal law can manipulate how a non federal actor carries out a federal function. Now, the exceptions are listed in the Constitution. For example, in Article 1, Section 4, it authorizes Congress to override state legislative regulation and congressional elections. So, Congress's power to constitute, that is to say, to set up and regulate tribunals inferior to the Supreme Court, gives it some authority over jury rules. Several amendments grant Congress power to protect individual rights, but other rules pertaining to these federal functions are fixed by the Constitution. The courts deduce those rules from the text and history of the document. Most lawyers, and really, I think probably even most law professors, are unaware of this special area of constitutional law, and this is because, like most of the Constitution, as I mentioned before, the subject is simply not taught in law school. So this ignorance has led to some very common mistakes. For example, the current national popular vote movement is based on a misconception that state legislatures may undercut the Constitution's presidential election and electoral college mechanism. Also, some claim that state legislatures or electors may manipulate the amendment process by using their 10th Amendment powers. The now moribund Compact for America proposed was based on this false premise, which the courts have repeatedly rejected. And still another mistake is that because an amendment convention executes a federal function, the Congress can control it. But as I just noted, the rules and protocols for carrying out a federal function come from the Constitution and not from Congress. So, getting back to where we were before about the excuses coming from these states as why they can't do anything, uh, essentially, when acting as a federal function, they do not need the governor. They don't need the governor to call them into session. They don't need a two-thirds vote, as is required by some state constitutions, to call themselves into session. If a majority vote in each house uh, to call them into session, they can do that. They could hold hearings, they could pass the necessary resolutions, and they don't need the governor. And they are not even bound by the rules in their own state constitution. So this gets to the real problem with the strategy of Trump's legal team, and this is something that I have been saying over and over and over on this show, that the courts were not the right venue for this. So it's trust that there are legal mechanisms in state courts to pursue issues like this. It that is to say that it's true that there are legal mechanisms in state courts to pursue issues like this. But even that is a poor place to start. And in fact, uh, Trump's goal from the outset seemed to be that he wanted to get this thing into the federal courts. And my guess is that because he has one thing that he has done throughout his presidency uh, is that he has been uh, shifting the courts, the federal courts, in a much more conservative direction. And this just actually, I think, is a fantastic thing. There are very, very few things Trump did for which I wholeheartedly approve. And the way that he has been reshaping the makeup of the federal courts is one of those things. But he seemed to think that this meant that these judges and justices owed him some kind of loyalty personally. And now the entire purpose of reshaping a federal court in a more constitutionally conservative direction is to get judges and justices who will always remember their first loyalty is to the Constitution. And that's what these courts did when these cases were brought. The federal courts were absolutely the wrong venue. Even state courts were not flat out wrong because they do have some say in these federal matters, but only as directed by the state legislatures. Which is why going to the courts first, then only after failing there, then going to the state legislatures was a stupid choice. The courts were not the right venue. Even constitutional lawyers I know who talk about this, who both like and respect Rudy Giuliani, have been very clear in their assertion from day one that he was never the right man for that job. He was simply not up to it. And it was not an area of law he is familiar with, and his abilities made him the wrong person for the job. And the people he had working for him were absolutely the wrong people for that job. Trump needed a top tier civil litigator. He needed people with experience in information technology, and he needed someone with some experience and as a quality PR person. So, turning over the results of an election in the courts, especially in the very limited amount of time that they had, would have been virtually impossible. But when Trump decided pretty much from election night itself that his strategy was going to be to drop a bunch of lawsuits and hope something stuck, this was always a terrible, terrible decision. Now, if you were asking me, I would not rule out entirely the idea of lawsuits. I think possibly several very targeted lawsuits with a very limited scope in state courts may have been justified. But the plan from November 4th should have been to go to the state legislatures and say, look, Title 3, Section 2 of the U.S. Code says that if there is, if a clear winner does not emerge, that you, the legislatures, are supposed to convene and you are supposed to grab a hold of it. But they didn't even begin trying to do that for anywhere from 3 to 4 weeks after the election. The fact is, at that point, it was already far too late. It is actually the same thing for the case of Texas versus Pennsylvania. Now, I have done 2 entire videos on that case. If anyone is interested, explaining it, I showed you the thumbnails for them a few minutes ago at the beginning of the show, but um, they're the ones where I'm explaining Texas versus Pennsylvania and the doctrine of standing, and more importantly, explaining why Texas didn't have it. Now, essentially, to get a hearing of original jurisdiction in a federal court, you must develop standing, which means you must establish that there are 3 qualifiers that must be established under the Constitution, uh, essentially as a case that the founding era courts would have recognized and would have taken. And the 3 elements that you must prove are injury, causation, and redressability. Now, something interesting, and this is actually, to be perfectly honest with you guys, a place where my opinion has slightly changed since I made those videos, is that I made the case that the Supreme Court, when they said that Texas didn't have standing was right. And I still stand by that. They were right. It didn't have standing. Uh, but I have changed my reasoning for why they didn't have standing actually. Um, because initially I had said that there had been no injury. And I've in taking a closer look at this now, I've actually realized that I overlooked something very important. And that is that the state of Texas didn't just bring their case as the state of Texas. They brought the case patens patria, which is a Latin phrase, and it essentially means parent of the country. And this is a legal doctrine that meant Texas was bringing the case on behalf of its citizens, not just the state itself, but the citizens. And that the other states in question, being Georgia, Pennsylvania, Wisconsin, and Michigan, acted in a way that Texas alleges they acted, while you can't establish that they damaged the government of the state of Texas. You could establish if they had acted the way the lawsuit claimed, you could have established that they damaged the voters of Texas. Now, the reason I say this case still should have failed and that it still lacks standing, despite the fact that I do think I have changed my opinion that there was indeed an injury, has to do with the third thing, which is redressability. And let me just, I guess I can go over these real quick for you guys here. Injury, causation, redressability. Injury means you show that you have to be able to show that there was an injury that you have suffered. Causation, the second one, means that you have to show that the defendant, the person who you are suing, was the cause of that injury. And the third one, redressability, means that the court has to have a mechanism by which relief can be granted. So the reason I say that this case still failed as a matter of standing is because if you look at the date the case was brought, it was brought on December 7th. And again, the drop dead date for all of this was December 14th. Now, what Texas was asking the Supreme Court to do is, all within 1 week, consider the case, hear oral arguments, draft an order, issue the order, send it to the state legislators, or ordering them to come back into session, and to have those state legislatures have a hearing and an investigation, and to make a ruling and a resolution with respect to the choosing of electors, and all that would have need to happen in the period of a week. So, the fact is that while the court may have had the ability, theoretically, to for redressability, they didn't have it in the time allowed. And I've come to the conclusion that had you brought that case on November 7th instead of December 7th, we would be talking about a very different case entirely. And I actually think we might even be talking about a case that would have had some chance of success that the Supreme Court might have actually taken up. So, yes, these are just a number of the ways that I think if Trump had had a good legal team and a solid strategy that he could have certainly. I'm saying if there was the fraud that he claimed there was, and I'm not saying there was or wasn't. I'm just saying if there was the fraud that he claimed, there are things he could have done that he didn't do that, if his claim was right, would have had a very good chance of success. But yeah. Anyways, that's pretty much all I had for you guys here today. So I hope you enjoyed the show, and if like I said at the beginning of the show, if you like this show and you are not subscribed to the channel, if you want to take a second and subscribe, I would really appreciate it. And then if you like this episode enough that you would be willing to take a moment and to help me grow the channel by just sharing out this video either on social media or send it to someone you know who you think may be interested in hearing this. anything like that that you guys do for me is are all things that I really, really appreciate. And I've noticed over the past couple weeks the channel has been growing at a steadier rate than it has been since I started it a little over a year ago, which is awesome. So I'm starting to see new subscribers almost every day, which is just absolutely fantastic. And I really, really appreciate you guys coming and watching and listening and commenting and leave a comment. Let me know what you think about the show. And if you loved it, let me know why you loved it. If you hated, let me know why you hated it. I'm open to anything really. And also, if there's a topic you want me to cover, like if there's a question you have that you would like answered, or there's an article that you think you would like to get my take on, or if there's just a general topic you would like to learn more about, if it's something that you think that I would be sort of knowledgeable enough to address, just if you get to know me over time, I think you'll get a good feel for what I am and am not aware of and where my strengths and limitations are. So if there is anything like that that you have for a show idea for me, I would love to hear it actually. I want to start putting out shows on a more regular basis, and that's going to require me essentially it's going to require help from you guys because I don't have time necessarily to always be looking for show topics that are good, like current event topics, all the time. While I'm also trying to do some of I guess what I call the big idea videos that I do, where I'll talk about larger issues. I'll cover a part of the Bill of Rights, like the Second Amendment, or I just recently did a video about the evolution of the Bill of Rights. The whole I've got part two of that coming up. So I do big stuff like that, and in between, I want to do more current event stuff and topical things like this. And if you have any suggestions for me, either just let me know, leave a comment down below, or you can send me an email specifically to an address I set up for that for show suggestions, and it is categorical imperatives at gmx.com. So if you guys would do all that for me, help me keep growing the channel, I would really appreciate it. And until next time, as always, delenda est Carthago.